Good evening. I'm Albert Conforzi. I'm a senior personal injury litigator. I've been practicing law for almost 31 years now, and I'd like to thank the Afro Mosaic Health Guide for giving us the opportunity to provide information to the community on issues that matter. According to Ontario law, it's the responsibility of stores or businesses or private property owners or municipalities to ensure the safety of people that go onto their premises. In the event of municipalities or cities and premises liability cases, there are special rules that can apply. But generally in Ontario, the law dictates that claims for slip and fall accidents must be filed within 2 years. I do say specifically that there are special rules for cases involving municipalities and cities, and if you are injured on a sidewalk or on municipal premises of any sort, you should immediately seek out the assistance of a lawyer in order to assist you in notice to the municipality, which has to be made within 10 days of the event. What kind of special problems are there with respect to slip and fall accidents is the question. Answer. In order to succeed in these types of cases, it's going to depend on where the slip and fall accident happened and how it happened. You have to be able to prove negligence on the part of the property owner for allowing a hazardous condition to exist, and in a situation where there is potential for injury to occur. In order to do that, it can be as simple as taking pictures of the area as soon after the accident happens. Most people carry cell phones with them these days, or are with people who have cell phones, and those cell phones are equipped with very good cameras, and it doesn't take very much in those circumstances to take a picture of an area of sidewalk, for example, that might be covered in ice and snow. If you don't do it at that time, the problem that can happen is that by the time you go back several days later, there's been a thawing that's happened and the sidewalk is no longer covered with ice and snow. And in those circumstances, it's very difficult to convince the city in that particular example of the fact that they have failed to meet their obligations to make sure that the sidewalk is clear or reasonably clear enough for people to use. Question. I once heard someone use the expression contributory negligence. Does that have any application in this particular case? Answer. Contributory negligence deals with your own responsibility for what happened and whether or not you contributed to the injury by not properly looking out for your own safety, or not wearing proper footwear, or not paying attention, amongst other things. Whenever these types of cases are brought, an element of contributory negligence is raised by the other side, and the answer to it will lie in how much information and documentation we can bring to the event by way of witness statements or photographs that take into account what the circumstances were at the time, what your footwear was at the time, how reasonable it was in the circumstances. However, having said that, if you weren't walking where you were going and you stepped off a curb and fell as a result, the reality is that you will be found to be contributorily at fault, and that means that your damages will be reduced by a percentage of your contribution. If you or anyone you know has suffered a slip and fall accident, please feel free to contact our offices and speak with Lily at 416-734-0428.